Yep, recording. Yep, so there's a question about the Acts Interpretation Act.
Yeah, so there's a specific comment that the commencement clause does not apply. So does that mean that Section 4 of the Acts Interpretation Act does not apply in relation to this? So the consent is given on the 30th of July, so that would mean that it's effective in August. But because there's that specific clause, does that mean any decisions made prior to the the act coming into effect, it doesn't cover that?
Which specific clause are you talking about?
Right. Just with the specific commentary about when it comes into effect, being that Section 2, the commencement, and it says, I've made a note that says no power of the minister to make an order prior to the commencement. It must have been mentioned in one of the tutorials. So I'm just wondering, is that the case? Because the specific comment about the commencement, does that mean then that Section 4 of the Acts Act does not apply?
I know, because I answered something today from Margaret, I think. Hang on.
I think that was along the same line. Maybe I won't waste time. I'll go back.
No, it's all right. I'll just quickly look at it. I don't have the act up in front of me. I'm just pulling it up now.
I think there's someone that hasn't put themselves on mute.
Hang on, I'll figure out who that is just a sec. Everyone's on mute now. There we go. Okay. Look, I don't think this rules out the operation of Section 4. Section 4 of the Acts Interpretation Act probably could have application because it is probably an instrument of an administrative character, and 4 is construed broadly enough to capture it, I would have thought. An instrument probably captures a TEO. So that's the answer to that, I think. I haven't had to look at it in depth, but I have had to look at what an instrument is before, and I know that it's very broad. Does that answer your question?
Thank you.
Is that
yes,
you?
Thank you.
Who was that, Sheree? Yeah.
Righty,
Yes.
sorry. Does that mean then that, so I just want to clarify that anything done prior to the act coming into assent would be invalid?
No, I think a TEO issued, this is what we were just discussing, a TEO issued before the act coming into force probably could survive by virtue of Section 4 of the Acts Administration Act because it is an instrument of an administrative character.
Okay, thank you.
I think you might find it is. I think it's arguable anyway. Any other questions?
Bridie, Mike, on your one tat we'd done regarding the, I know it's not going to be discussed regarding the severance issue in Section 30, but you'd said that if Section 14 is deemed unconstitutional, and I can't get my head around why Section 14 per se would be unconstitutional, because that's giving the review, unless I just misunderstood the question.
I think it is probably, I think it's a relic of the complaint that was made by the Law Council of Australia, which said that the penalties that were capable of being imposed by the minister were judicial in character, and that the minister's power was effectively an exercise of extrajudicial power, and that, you know, that's unconstitutional by virtue of Boilermakers, for example. And 14 was introduced to provide a review in circumstances where people were complaining about the arbitrary concentration of power in the hands of the minister and the sort of administrative penalties that were being issued. And I think that people were saying, oh, you know, it's unconstitutional. It doesn't fix the minister's exercise of power. I don't think that it's correct. I think they've just left it there because it's to deal with what they apprehend might be a constitutional challenge in the future.
Sorry, Bridie, then another question. I don't know if it's a silly question, but there's I don't know which section. It says the minister must notify the person of who's got the TO personally. Does that mean he has to physically, personally go and notify the person, or can he do it by delegation?
It depends on the section. So you'll need to find the section, because, you know, the delegation power carves out certain provisions. So it'll be what, section 15?
25.
No, where he says he must notify him. Oh, you want to look at that first?
No, section 15, section 14. So would it be 12? Hang on. No, it's 12. Revocation, 11, revoking. I thought it was 8. So as soon as practicable after the temporary, so this is section 10 subsection 8. As soon as practicable after a temporary exclusion order comes into force, the minister must cause such steps to be taken as are, in the opinion of the minister, reasonable and practicable, to bring to the attention of the person the content of the order, and if the person to whom the order relates is 14 to 17 years of age, to bring the attention of a parent or guardian of the person the content of the order.
Sorry, there's another one. I'll find it for you, where he says personally. I think it's a return permit.
Oh no, the return permit has to be served.
Yeah, that's 17.4 says served personally. Return permit.
Yeah, 17.5.
But does that personally means person, not the minister personally does it, but to the person personally?
Yeah, so
what does personal?
Personal service means personal service, because the whole point of this act is, remember, that these people, it's not to keep them out, it's to keep them under surveillance and you know, with checks on them when they return. And we want to make sure that they know precisely what the conditions of the return is. And so that's why it's required to be served personally, so there can be no doubt that they've received it. So service by email.
The person sitting in Syria. So how? Person's now sitting in Syria or wherever.
Yep, they'll just have to be served personally. So they'll use whatever diplomatic resources they have, I would expect.
Is it like a service, like, so it's like the service of the court document kind of thing, like you got to go there and someone has to write, oh, I hand it to the person?
Yeah, I don't know, you need an affidavit of service, but you'd need some record of service. So see in 15.5, there are 2 requirements of service. One's on the person to whom it relates, and the other one's on their parent or guardian if they're aged between 14 and 17. And the minister is excused from complying with the service on the parent or guardian only if it's reasonably practicable to do so. So that would suggest that the real object is all about personal service of the person affected. Now, in terms of who does the minister get to do that, let's have a look at what 25 says about delegation. Yeah, the minister can, I think, can get somebody else to, the minister doesn't have to run around and serve everyone personally, obviously, because they can delegate. But it's only the language is the minister must cause, so that must mean the minister can engage someone, or someone on the minister's behalf can engage somebody else to do it.
So without 25, it can kind of already saying it can be delegated, just because of this wording.
Yeah, but the word, I mean, there's no problem because of the delegation power, but the minister may cause, or the minister must cause, means that the minister just has to set in train the personal service, i.e. the minister, has to get somebody else to do it. But I mean, the minister personally doesn't have to get somebody else to do it, because it can fall under an instrument of delegation if issued. Any other questions?
Last one. In the statement where I thought it was in Kiowa, which said that procedural fairness can be reduced to nothingness. But then I've seen that that's actually stated in Leger as well, and I'm confused where that's which case actually cites that statement. So
Brennan says it in Kiowa, and it's picked up in Leger.
Okay, but it emanates from Kiowa.
Mm-hmm.
Okay.
So what he says is, rather, the intention to be implied when the statute is silent is the observance of the principles of natural justice conditions the exercise of power, although in some circumstances the contents of those principles may be diminished, even to nothingness, to avoid frustrating the purpose for which the power was conferred. Accepting that the content of the principles of natural justice can be reduced to nothingness by the circumstances in which a power is exercised, a presumption that observance of those principles conditions the exercise of power is not necessarily excluded, at least where in the generality of the cases in which the power is to be exercised, those principles would have a substantial content. So, I think go back and have a look at this aspect of Brennan's judgment in Kiowa, because I think it's relevant. I mean, it's the one that's found it's threaded through all of the modern case law, and I think it's relevant to your understanding of Section 26.
And then, Bridie, if you could just go over again the difference between the UK separation of powers and the Australian constitution, where the separation of powers is entrenched, and why that would therefore not invalidate the TO, because it would not be unconstitutional. You could just go over that concept again.
Well, there's no single constitution in the UK. It's not a written constitution. We have a written constitution which separates our power into the exercise of government's power into legislative, executive and judicial. in the UK, it comes from the Magna Carta, that it's all prerogative power. So the power that resides in Parliament is all prerogative power, and ministers are exercising the prerogative of the Crown because it's a constitutional monarchy now. They're exercising the prerogative of the Crown, but they sit in the Parliament. And so the executive in Australia effectively exercises something resembling prerogative power, which is the power of the Crown. But because they sit in the Parliament, there's no delineation between the exercise of that prerogative power and the exercise of parliamentary power, because they don't have this constitution that we have. So if a minister were to make a decision of an extrajudicial nature, their constitution, because of that blurring of the line, their constitution doesn't delineate like ours does. That's an exercise of executive power, which is overseen by judicial power, the way in which the UK deal with it, so that there's not the complaint that there's effectively an exercise of judicial power by the Parliament, is to give that role to a judge sitting in the High Court in the UK. Whereas here we don't need to. We can have an exercise of administrative power, which effectively authorises administrative detention, administrative penalties. I mean, our entire immigration system is built on that. People come here, they want to enter Australia with unlawfully, quote unquote, and until they have a visa, so they sit in administrative detention. So one of the arguments, I think, in one of the cases we studied, was on the reading anyway, I can't remember what week, Al-Khatib and Godwin discusses all of this, that there is authorised by the Constitution acts of administrative detention, administrative penalty and the like, such that it is to be understood separately to judicial exercise of power, so it's not unconstitutional, whereas in the UK there's not that delineation.
Bridie, just a question on the, so we've got a number of legislative materials on the Australian Citizenship Act. In terms of the significance of those, are we purely looking in terms of the dual citizenship being able to be stripped away, which has been discussed quite a bit on Moodle and Facebook today? How much do we need to read into those materials?
I don't think very much at all. I mean, I don't think it hurts you to understand the statutory scheme in which all this power is being exercised. I mean, the thing that, don't be too distracted by it. This all arose because two of us put up that Four Corners thing just to sort of, give it a human face. I thought it was interesting because it gave it a human face, and then everybody was, saying, well, how can these people be sitting languishing in a Syrian refugee camp in circumstances where if they say, I want to come back, then a return permit has to be issued? And the way in which we sought to explain it was to identify the relevant sections of the amended Australian Citizenship Act, which if in circumstances where you act in a terrorist manner, you've deemed to have renounced your own citizenship.
Yeah, okay. That's fine. That answers my question. Thank you.
Bridie, hi. I've just got a quick question on the return permits.
Yeah.
It's not specified when the return permit has to be given. So we know that it is mandatory, but it doesn't say that I've read within the Act that it has to be issued within a certain time frame. As long as it's, as what I understand, it's as long as it's within a reasonable time frame. Can the minister actually decide that, 12 months seems fairly reasonable, or is it what a reasonable person might expect it to be for, let's say the security services to get a good idea of what the dangers might be?
I thought section 19 said something about it. Hang on.
Okay, because I was looking at 16.9.
15.3a says the return permit must be issued within a reasonable period. And I don't think he could argue that a reasonable period was a year, could he?
Well, that's what I'm asking. So what is a
It's
reasonable
15
period?
It says a return permit comes into force on the day specified for the purposes of 15.4c. And 15.4c says, no, that's not it. Yeah, but reasonable time. Okay, so yes, you're right. It's 3A. So there's no. It doesn't have to be issued within 14 days or something along those lines. But it has to be within a reasonable period after the minister received the application, or if the person is to be or being deported within a reasonable period after they become aware, or if the minister decides under subsection 2 to issue a return within a reasonable period. So reasonable always is construed in the context of the Act. So you know that.
Mm-hmm. Yes.
And so what constitutes reasonableness in the context of the Act is a matter for you guys to decide.
I think we also said in the tutorial, because it talked about the guy's dad dying within 3 weeks or something, it wouldn't be reasonable to issue it a month out.
Yeah. Well, remember the Act is all about issuing a return permit.
Mm.
That's what the Act's about. So, and you look at the various matters that as to who can issue a return permit, and also the conditions that can be imposed upon a return permit, the consequences for failing to comply with one, and all of these together, read these together and you'll understand what a reasonable time is. I mean, it's not strictly going to be 14 days, but 14 days is your typical reasonable time period. In a lot of pieces of legislation, courts have determined a reasonable time, for example, to comply with a notice to produce is 14 days. But if it's a particularly onerous and burdensome notice to produce, which is like a subpoena, then you would say that you should be given a longer period of time. So it's all just circumstantial and contextual.
Righty, it actually mentions it in the explanatory memorandum.
Yep. What does it say?
It actually says in here that it's that it specifies the day the permit comes into force and the period it remains in force, which must not end more than 12 months after the person enters Australia.
Yeah, that's the time. That's the time it can be enforced for.
But the thing is, and it says that it's up to the minister for when he actually allows that permit to be put in place.
Yeah, but it has to. But we were talking about reasonable time period. He can't just let it sit for 12 months. I wouldn't have thought. The return permit. There may be an argument around a return permit coming into force when it can be served. I don't know. It's a question for you guys to figure out. That's one of the statutory tasks, is what constitutes reasonableness. And as we looked at in the practice exam, reasonableness was construed specifically in the circumstances of that fact scenario. So Isabella, do you want me to answer this question? Return permit, can you just clarify if this is right? If a return permit is requested, it must be granted, yes, but only when the person is being deported or extradited to Australia. No, I think you just ask for it. So you need to read section 15, isn't it?
15.3c.
No, 15.3c, I thought we were just dealing with, weren't we?
Just section 15.1, it says it must issue a return permit if there's a TEO in force against the person on their application, blah, blah, blah.
Yeah. If a temporary exclusion order is in force in relation to a person, the minister must issue a permit under this subsection to the person on an application by or on behalf of the person, or if the person is to be or is being deported or extradited to Australia. So there's two circumstances, Isabella. And then the minister can issue it if the minister chooses to, is what 15.2 says.
Brady, we had a question in topic 3 in one of our tutorials, and it was question 2 on discussion on the counterterrorism bill and its implications for the rule of law. Is that pertaining to the whole question of the separation of powers and all of that which we've just discussed?
Yeah. Yes, that would be the main. I mean, our rule of law derives from our constitution in Australia. So there would be a number of rule of law questions around the TEO Act, and a lot of them are going to be constitutional, but the main one would be separation of powers and the validity of the exercise of executive power in the manner in which it is being exercised under that Act. I think I answered something on the Moodle today about this to some extent. I can't remember whose question it was. Was it yours, Emma? Can't remember. Maybe Margaret's. But it's look at the language of it and look at what it purports to do. It's just the minister has a reasonable suspicion that somebody has committed a terrorist offence, and so therefore is in a position to be able to effectively hold them on remand. So impose conditions on their re-entry in such a way so as their movement is restricted, not much differently to what it would be if you were refused bail or had bail conditions put on you when you've been arrested in respect of an offence. Now, ultimately, you may be exonerated or you may never be prosecuted. I think one of the differences, no, it's not even a difference. You can be arrested by a police officer and the DPP says, no, they're not going to prosecute. So it happens all the time. I don't think it's any different. You don't have to be prosecuted. So I think that it's just an exquisite exercise of administrative or executive power.
Really quick question. Topic 2, delegated legislation. We're just looking at delegation as in section 25 of the TEO. We're not worried at all about delegated legislation, are we?
No, but there are some good topics in delegated legislation with respect to the validity of provisions and certainty and ultra vires and stuff like that. So I wouldn't be madly studying it, but don't abandon it entirely. Just refresh your memory about some of those propositions and principles if you have time. But I wouldn't be madly worried about it. There's no delegated legislation. You know what the legislation is. There's no regulations, nothing. It's just what's in that legislation folder, and obviously the Acts Interpretation Act and the Constitution. Angela said, do we need to focus heavily on separation of powers and the rule of law for the exam? You don't need to focus on it heavily, but I can't imagine how you would be able to avoid it. It's just an intrinsic part of administrative law. So to the extent to which it informs understanding the exercise of power, yes, but you don't need to write an essay about it. There's no specific question about the rule of law or anything like that. I'm not asking one single question about the rule of law. Okay. Yeah, who's this? Go, Josh.
What happens after the 12 months? Like you said, when the day that the return permit comes into force, that they can't enter more than 12 months after. After the date. What happens after that? Is the TEO just still in force then?
No, the TEO evaporates, so it ceases to exist. It's deemed revoked when they issue a return permit.
Okay, and if they don't enter within the time specified,
they can issue. So the minister can issue as many TEOs as they like. Okay, so it can be exercised from time to time, and just because you've had one against you doesn't mean that they can't issue another. So if they issue a return permit and you don't return, and the return permit expires within 12 months, they can issue another TEO.
okay, right. Thank you.
Now, Akio says, I'm still getting confused with reasons. There's no reasons apart from the minister giving reasons to the review authority. So we can't argue if it's reasonable or relevant consideration. Yes, you can, because you don't need reasons to do that. You just look at the outcome, and if the outcome is has clearly been arrived at in circumstances where they haven't taken into account a relevant consideration, or there's clearly, it's an unreasonable outcome given the facts, then you would be able to still have it quashed. And there's a case that stands for that proposition, and it's WAH D, WAHD, I think, at like paragraph 35 or something. Let me find it. Maybe not WAHD, what is it? WHK, WHT. Maybe that. Nope. I can't. Let's try and remember it. It's it's a W case.
Is that WZRAH?
No, it's much older than that. God, I used to cite it all the time. WA. Not a. Is it WAHR? No. Yes. Nope. W.
Is it a 2004 case?
Yeah, maybe.
I think I just saw it. Hold on.
It's full court of the federal court. Not WAHW. It's not that. I'll think of it. Anyway, I'll just have a look in one of my sets of submissions.
Is that one right that I just put in the chat?
No. God. It's WAHD, I thought. I don't know why it doesn't show up. Nope. Oh, WHR. Oh, God, I've done a case. That's not it. Let me find the bloody case. Anyway, I'll find it and I'll put it on Moodle.
Thank you.
It's not WZARH. Nope. It's not WH. Don't get bogged down in it. I'll find it as soon as it's one of those things, you know, when I stop sitting here trying to think of it, I'll think of it. Any other questions? Anyone can ask anything.
Do we need to panic?
I don't think you do. I don't think you do. I think you're all going to do fine. I think you're all going to pass. I mean, unless you're doing absolutely no work between, you know, or you haven't done any work the whole time. I mean, you know, you'll be fine. I mean, the exam is you've already been prepared for the exam on the basis of the assignment. The assignment's not going to be what you had to think about for the assignment. You'll need to think about again for the exam. We've done so much work on this Act. You'll be fine. We've done the practice exam. It's all just, I mean, you understand the way the language works and the structure of the Act works, and you just need to familiarise yourself with it. We've discussed a lot of the issues that are to be considered in the two statutory interpretation questions. You're going to get the problem facts tomorrow, and you're all going to just go berserk on Facebook. I can see it now. And I think, you know, you'll immediately be finding things wrong with it and errors and issues and stuff, and you'll just when you get the question, you'll go, right, I'm ready for this. I think you'll be fine. As long as you've got some time to work on it between now and Wednesday, I think you're going to be fine.
So are you okay with us talking about it on Facebook?
I don't think I can avoid it. I mean, and look, let's be real about it. I mean, you're all going to, you're going to talk about it somehow with somebody. That's just human nature. So you know, I don't have to shut that down. You won't, some of you, you know, if you want to start your law career plagiarizing, so be it. You know, it's not I'll pick it up. If you're going to plagiarize, I'll pick it up, and then you'll have to explain that to the admissions board. Matter for you. But I don't have a problem with. I'm not saying you're plagiarizing. I'm speaking rhetorically. You know, so I mean, of course, you're going to talk about stuff. I mean, when you get a take-home exam, people talk about it. It's not. I mean, I did, but I didn't plagiarize. So I'm just saying, you know, you shouldn't steal each other's ideas. But I can't shut down the fact that you're all going to naturally talk about it, and that's fine. I don't think there's a problem with it. But I think if you start copying each other, I'll pick it up, and you know, that's I can't stop you, but that's the way the cookie will crumble for you. Do you understand what I'm saying? I'm not slurring anybody. I'm just saying, just be careful. There's a line that you should be aware of and not cross.
So sorry, I'm harping on this, but are you saying that we would be able to then almost get a draft answer out? Because I don't know how we would copy anything else from anyone else. Are we using case law and?
Yeah, you'll be able to brainstorm a whole lot of different answers to questions that you think I might ask. I mean, this is what the practice of law is like. Nobody ever says to me, answer this question, Bridie. They just say, advise and appear. So I read it all and I figure out what the answer is and the approach and stuff like that. So you getting that material ahead of time, you'll just be doing an advise and appear. And then when I ask a question, it'll be like what a judge does when they ask me a single question.
Sorry, I'm a bit confused. Then what is going to be in the, if all the materials are going to be out tomorrow, what is going to be on the actual exam paper apart from question 1 and 2?
And 3. You don't know what question 3 is.
3. But all the facts about question 3 is going to be out.
It's all the annexures and stuff, like the emails to the minister or whatever that we had in the practice exam.
So there's going to be 17 of those annexures.
Where do you get 17 from?
Wasn't it 17 pages? Then I thought
probably.
It was...
Oh, it'll probably be 17 pages. Yeah, there's like 17 pages. Yeah. Yep. There's a lot of pieces of paper. That's why I'm releasing it early. You're going to be fine. Seriously, when all of this stuff gets released to you early, you're going to go, oh, great, and you'll be madly working away. But I mean, it's not. You know, even in the assignment, a lot of you probably worked with each other and answer questions with each other and stuff like that. I didn't detect a lot of similarity of answers at all. So you just that's fine. You'll all be madly talking to each other and picking up bits and pieces and stuff. But I mean, it's in your own interest not to sort of say, oh, did you see this and did you see that fact? I mean, you would be, it's in your own interests to just keep it under your hat and not, not help each other too much. Because if you're doing it on Facebook and places like that, other people are going to pick it up, and you just don't want to find yourself in a position where you've compromised yourself, because you are training to be lawyers. So just remember, this is what I'm trying to reinforce in your minds. Don't go overboard in workshopping it and working as groups or anything like that, because it has the propensity to backfire on you. Kayla's asked, Section 4 of the Acts Interpretation Act may be relevant. Is this the only section we need to take into the exam? No, I think you should take in the Act. But there'll be, when you get the problem question, you should be able to figure out which sections of the Acts Interpretation Act you need to have ready. Not the problem question, the problem material.
I've got a couple of questions, Brady. I've read a lot about jurisdictional fact and error, but I was just wondering, I have it on my list. I was going to look into it more. Just haven't got to it yet, but I thought I'd ask anyway. Error of law and also error on the face of the document or something. How are they distinguished from jurisdictional error?
Error of law on the face of the record, is a lesser form of error than jurisdictional error. So there can be an error of law on the face of the record, and the record in New South Wales includes the reasons, but in other states or territories, for example, it doesn't necessarily include the reasons. So you're stuck in ancient territory of Craig, which was just the order itself. And it can be, for example, something just quite basic, like an error within a fact. So a fact-finding error is an error of law on the face of the record, but something that would not necessarily give rise to jurisdictional error can be error of law on the face of the record. It doesn't have to go to jurisdiction. It doesn't have that requirement of materiality, etc. Whereas jurisdictional error has to be a condition. It has to be the breach of a condition upon which the exercise of power is predicated. Whereas error of law is just an error of law. It's a lesser form of error.
What would a practical example be of error on the face of the record?
Error of law on the face of the record?
Yeah.
When you make a mistake within jurisdiction, so like, you've got jurisdiction to make a decision with respect to a ruling on evidence, for example, and you make a mistake with respect to the ruling on evidence. So you say that something is not excluded under the hearsay rule, but it should be excluded under the hearsay rule, for example. That would be an error of law on the face of the record. Not for an administrative tribunal, because most of them aren't bound by the rules of evidence, but some of them are. And that would be an error of law on the face of the record. So it doesn't go to the tribunal's jurisdiction, but it's still an error of law. That's a very basic example. Do you understand?
Thanks, Brady. I was just going to ask also quickly, I've been thinking a little bit about the application for revocation, and I was wondering what the utility of it is, because if you don't really have any sort of reasons or know why the minister's made it against you, apart from if you had a general understanding of the Act, then I can't really see it. Not that I think that it's actually important, but I can't really see how it's going to be any point of bothering to apply for revocation, because if you just deny it, the minister's not going to really care. I was just wondering if you had any thoughts on this.
Well, revocation can be for material reasons or just procedural reasons. So, for example, you know, if there's a TEO order out against you, if you try and re-enter Australia, you committed a crime. If you're in knowledge, if you have full knowledge of the TEO order, and the you know, maybe it was invalidly issued against you or something like that, you could apply for it to be revoked rather than go and seek judicial review. It's a specific power being given to the minister to effectively undo what they've done. So it doesn't always have to be as a matter of clemency on the part of the minister. It could be because the minister you know, has made a mistake, and the fact that there is a power in the minister to revoke something, you know, I think we had a discussion about this in some questions that Nikki asked about functus officio and stuff like that, to determine whether or not an act is ever like whatever, there's no such thing as functus officio in administrative acts because they're capable of being undone for jurisdictional error. But it's probably more indicative of the fact that the power can be exercised in such a way that it can be undone. So the minister can't say, "Oh, too bad, so sad, I've made a TO against you, nothing I can do about it." I mean, the Parliament has been very careful to instill in the minister the power to revoke a decision in circumstances where maybe it's procedurally wrong, or they've changed their mind, or circumstances permit, or clemency requires, etc. So it's probably to counteract that notion of functus officio and finality in decision making.
Okay, yeah, that makes sense. That's about all I thought it could really be used for, because I don't think that someone who gets a TEO issued against them is going to be able to make any sort of meaningful submissions in their revocation application as to why there shouldn't be one against them if they don't really know exactly what the minister based it off, because he doesn't have to give reasons.
Well, he does have to give reasons if it goes to a reviewing authority.
But you're not gonna get it, would you? Like if you are the person who served TEO, you wouldn't get the reasons. So
why not? You could make an application. You could make an application that you'd be given that. So there's a whole variety of different pieces of legislation that would permit you to get your hands on it. So freedom of information type legislation.
Even if it was just a summary, if it was against national security to divulge the information?
Well, remember, the minister doesn't have to give his reasons if it's against the public interest. Like he has to give reasons, but he can exclude material, on the public interest. So you're in the same position, for example, as Mr. Legay or Mr. Jafari or something like that.
Acting under dictation. In my notes, I've put that it's very unclear in terms of the laws relating to it. If it goes into, because I'm still looking at the delegation and dictation and everything, can you say it's very unclear, the laws relating to this, but these things may happen, or?
Which ones? Which things may happen?
Well, depending on what the facts are, but just say, because in my notes I've put that it's the laws relating to acting under dictation are very unclear, which doesn't actually help me a whole lot. But then maybe going to the ANZAC case or the IPEC case, and it would depend obviously on the facts of what we're given in the question.
Yeah, well, I mean, we had a short discussion about this the other day, and I kept in the practice exam, and I kept referring to Desmond and getting Desmond to answer the question.
The TICNA one. Yeah.
It's around. Yeah.
Bridie, do you mind if I just add on to what Emma was just saying? For example, if we got a question that the delegate he can exercise, he's got express delegation to exercise, for example, the power of Section 10, subsection 2. And if he exercises that power, according to Section 34A, I think it is, of the Acts Interpretation Act, that act is an exercise entirely of his own decision making.
Mm.
And then when I go down into my notes, for example, the Caltona principle wouldn't apply because it's not an implied power.
Mm.
And Section 25, subsection 3 says the delegate must comply with any written directions by the minister.
Mm. Mm. Yeah.
So, like going through some extra notes, I found that says that unless statutory, there's a statute expressly conferring the minister with power, giving binding directions, then really the acting under dictation and inflexible fettering of discretion wouldn't apply, would it?
No, so yeah, that because that power exists to issue guidelines for the exercise of the power, then there is no undue fettering because it's legislatively supported. So ministers are entitled to fetter the exercise of discretion to some extent. If there is a statutory power to create guidelines for the exercise of power, and you'll find it a lot in migration, for example. There's lots of statutory guidelines, and these would be, pardon me, these would be statutory guidelines, and arguably, if a delegate acted outside of those guidelines, they would have acted contrary to law because those guidelines would have legislative effect. So whatever if the minister issues guidelines pursuant to that provision, then they are statutory guidelines, arguably, and in those circumstances, if a delegate acts outside them, then the delegate has acted contrary to law. So yeah, there wouldn't be any acting under dictation in those circumstances.
And would those acts of the delegate, would they be considered to be acts of the delegate or acts in the name of the minister? So would Section 34A of the Acts Interpretation Act actually apply, and they would be considered as acts of the delegate or acts of the minister? Sorry, does that make sense?
The acts of the delegate. When the power is delegated, then it's an act of the delegee. And that's why the fact that there's statutory permission to create statutory guidelines means that the way in which a delegate exercises their power needs to conform to these statutory guidelines as made by the minister, and to act contrary to them is to act contrary to law.
So could I ask what section
Okay,
it
that's
was
the point I
again?
didn't understand.
Yep, sorry, Orsif, just finish off.
So yeah, that's what I can understand is unlike the other examples I looked at, the delegate actually had it didn't have to, like, he had his own mind and thinking and decision making, whereas he is under dictation.
No, he's not acting under dictation. He's acting pursuant to a set of statutory guidelines promulgated by the minister. So, I mean, he can exercise his or her discretion to the extent that a discretion resides in a delegee under this Act. And I don't think there's much discretion. It's all just you have to do X, Y, and Z in accordance with a statutory prescription. But to the extent to which there is any discretion whatsoever, it needs to be in accordance with these guidelines. I mean, that it would still be an exercise of their own discretion, but the guidelines would say you have to take this into account, you have to take that into account, in these circumstances you don't issue it. So for example, the minister can delegate under the Migration Act to his or her delegates decision making with respect to, for example, let me think of one, deporting somebody, right? In exercising a discretion to deport someone for a serious criminal offence, there's a whole series of guidelines and they're very prescriptive. So that you have to take this into account, that into account, this into account, that into account. It's a bit like the way Section 10 reads of the TEO Act. And I suspect any guidelines promulgated by the Minister under this Act will be similarly prescriptive. It doesn't mean you're acting under dictation, because you're not acting under dictation, because acting under dictation presupposes that you have a free discretion, a discretion unfettered, whereas the Act permits a fettering of the discretion by virtue of these guidelines. So you're not doing anything contrary to the legislative intention, whereas in circumstances where guidelines like this don't exist and there's no statutory prescription for it, if somebody says, I want you to decide it this way or I want you to decide it that way, that is acting under dictation. Whereas here, they're not telling them how to decide, like you have to decide it this way or decide it that way. They're just saying, these are the things you must take into account, or these are the things you must do before you make a decision. One is authorised, one isn't. Acting under dictation, it isn't authorised. Does that answer the question, Orsuf?
Yes, thank you, Bridie. Just yes, thank you so much. Just further, like an act done by a delegate. I know in Weir's case, the act was in the Macquarie University breach of statutory obligations. A mistake by a delegate, could that perhaps entail the same principle that the minister relying on that mistake by the delegate could perhaps also be a jurisdictional error?
Yep.
That's Tickner, isn't it? Where the summary wasn't comprehensive or good enough by the lady, and he relied on it, and it should have been a lady. Yeah.
Yep. If you can rely on, someone can write virtually your entire decision for you. Two things: if there's a mistake in it, tough. The decision is invalidated by virtue of that mistake. And secondly, if the minister doesn't bring an active intellectual process to bear upon the decision, then it's invalidated by virtue of what was said in you failed to take into account a relevant consideration. It's effectively Tickner and Chapman.
One of the rare cases in the Act he does seem to delegate, or it does sort of seem to indicate in Section 18.2, it says the Minister may, in writing, authorise any person to receive applications on the Minister's behalf.
Mm-hmm.
Is that quite, I mean, is that normal to sort of spell that out? And is that purely just somebody receiving on their desk, on behalf of the Minister, the return permit application, and that's all it allows? So he's saying that somebody else can basically collect his mail for him?
Yeah. That's what it sounds like. It also would be relevant to the whole reasonable time question of when you issue a return permit if other people. So, I mean, the minister, not everybody knows how to contact Peter Dutton. And so, the consulates can receive applications, a whole variety of other people could receive applications. I have no doubt that he will be delegating to a whole lot of members of the diplomatic corps these powers to receive these applications.
One other quick question. So in Section 25 delegation, it says subsection 2D, the discretion to issue a return permit cannot be delegated or subdelegated or whatever by the minister. Why would it use the word discretion to issue a return permit? Because the minister, I mean, does the minister have discretion to issue a return permit if he has to issue it anyway? Or is that taking in the process of they've applied for it properly and all that kind of thing, and he has to decide that they've put in the application effectively?
What are you talking about? Section 15, subsection 2?
Sorry, no, 25 2D says that he cannot, the minister cannot delegate the discretion to issue a return permit. And that seems to contradict the wording of 15.1, which says the minister must issue a return permit, but he can't delegate the discretion to issue it. But he doesn't have any discretion to issue it, does he? Or does he?
No, under 15.2, he has a discretion to do it on his own, of his own motion. Have a look at 15.1. 15.1A and B are the circumstances where he must do it. 15.2 is where he may do it.
And that's in terms of the flooding and everything. Yeah, okay, gotcha.
So 15.2, he can do it. Like, so, say,
in urgent circumstances, if they don't have their papers or something, they're caught up in.
Or if he wants to,
Yeah,
wants
okay.
to. Not every the TEO can be enforced for 2 years, but I mean the whole point is you'll issue a say somebody's standing at the border, right? You know, coming in on a flight, and the minister's issued a TEO immediately as they've got off the plane, then they can issue a return permit without this person ever applying to return, for example, because it's implied that they want to return. They don't have to actually orally say, I want to return, and they can be served by Border Patrol personally, saying the minister had issued a TEO against you, the minister's given you a return permit, here it is.
So now you don't have to go to prison or be fined or whatever.
No, it's just like that. It's just, basically, here's the return permit. You've got to go and sit in Goulburn Supermax now for 2 years or something like that. I mean, I don't know what the condition is, but yeah, it's a way in which, like, you wouldn't want to have to arrest somebody when, because the AFP are under different obligations when it comes to arresting someone. So say, for example, somebody's coming back in from Turkey right now and the minister knows that they've got on a flight in Istanbul and they're in the air, he'll issue a TEO right now and then issue a return permit the minute they get in. The return permit may see them go and sit in jail. Those sort of circumstances. That's one example, but there's plenty of others I'm sure we could think of.
Righty, can I just ask if there's an adverse review by the authority, is it possible to respond to that review if it's not in favour of you?
Who? The only person it's not in favour of is the minister.
But I'm just saying, the thing is, if the reviewing authority is sort of approved what the minister wants, then
it doesn't approve anything. That's the real distinction that you have to recognise in Section 14.
Yeah, okay.
The only thing they can do is nullify it. They can't approve it. They don't. Their decision is of no operative effect at all, and that's very clever when you look at it.
Yeah.
They're not affirming the decision. They're not revoking it. They're just saying there's an error. So if they notify the minister or whomever that there's an error, it's void ab initio.
Yep. Okay. So on another note, if the minister, for instance, receives an assessment from ASIO about somebody wanting to come into the country, is there any direction or what can somebody do if there's an adverse security assessment done against them?
That would be under ASIO, the ASIO Act. There's a whole division that deals with that, but you don't need to worry about that.
Okay, cool. That's good. Okay. I just thought reason being is that I was reading a case on BCX 15 versus the Minister on Border Protection, and it raised Legay and also Jafari on how they didn't receive procedural fairness. Yet Justice Wigney quashed an assessment because the person BCX 15 didn't receive procedural fairness. And therefore it was totally this way. Procedural fairness was reduced to pretty much nothing, and so far as Jafari and Legay, but now it's actually, there's a possibility that actually those decisions can be quashed, according to Justice Wigney. I'm just wondering if that comes to play in this situation where there's an adverse security assessment. Can the person who the TEO has been taken against, can they actually look at basically rebutting that decision?
Of ASIO or of the minister, when the minister takes into account ASIO?
Well, that's what I'm saying. The thing is that if the minister takes ASIO's assessment report, security assessment report and uses it as his for his reason for refusing the person re-entry back into the country, then is it possible then to actually look at contesting that decision?
Yeah, but remember that this act goes a step further than the Migration Act does, and it says the minister doesn't have to afford anyone procedural fairness. So you've got to always look at it through that prism and decide. So it's what Brennan said. It can be reduced to nothingness, but it's that part that I just read out from Kiowa. You have to look at what remains. What remains?
Okay.
Because the question is here is, if the minister doesn't have to afford procedural fairness, is there a duty? Is there a duty even? This is something you have to ask yourself.
Okay.
Is there even a duty to afford procedural fairness? Or does Section 26 just reduce the content or the scope of the obligation?
Because the terminology says he's not required, doesn't mean that he can't.
Yeah, but does that mean he doesn't have a duty? So remember, there's a case that sort of is along these lines. Do you remember which one we studied that's a bit along these lines?
Wasn't natural justice excluded in Lee and Said?
Yeah, but I'm thinking more about, does the minister have a duty? There was a case we looked at which was relevant to the writ of mandamus. Do you remember which one? M70, the offshore processing case. The reason why mandamus couldn't lie in that case, or Ainsworth. The reason why certiorari couldn't lie in that case is that, or mainly M70, is because there was no duty. Look at the language of section, I think it is 198 of the Migration Act. It's just that, yeah, Mia might also mention it, but just think about whether or not Section 26 absolves the minister of a duty to afford procedural fairness, or if the duty is implied. I mean, you've got to think about these sort of things. Procedural fairness will feature in the exam.
Well, Brennan does say it's supposed to be in the legislation or in the Act.
Well, see, does the minister have a duty to afford procedural fairness? Has this Act completely obliterated the duty to afford procedural fairness? In what and by reason of what does the duty to afford procedural fairness subsist? So where does it come from? What is it? Is it a common law right? I'm answering the question by asking these questions. But
common law right.
It's a common law right. So it's a duty that exists with respect to the act by an executive that does what?
Could you not say that you have to imply it into the Act by virtue of the other provisions that do imply procedural fairness, such as notice and to give reasons and all of that?
That's content. I'm looking at duty. Duty exists by virtue of the fact that this decision will affect someone's rights or interests. Okay, so that's just basic cure.
Yeah.
Okay, and then, but you need to look at whether or not this legislative tool that they've used to say the minister doesn't have to abide by procedural fairness, whether or not they've effectively got, obliterated the duty, or does it just go to content? So there's always two stages to procedural fairness: duty and content. So is there even a duty to afford procedural fairness? And I think what Nikki was saying answers the question to some extent, because there's still there's elements of procedural fairness. There's requirements of notice, etc., etc. There's a requirement of reasons. There's, there are some remnants of procedural fairness scattered throughout that act. There's applications. There's requirements to accept applications, decide applications. In those circumstances, you'd think there's some remnants of procedural fairness, and so it probably doesn't actually obliterate the duty. But it's a question. I mean, if I was sitting here brainstorming for the Commonwealth, I would be thinking, I wonder if this is capable of actually, disenfranchising the duty that exists at common law, because statute can override common law, you know that. So just think about it. I mean, that's what happened at M70. They rocked up saying we want certiorari, we want this decision quashed, and they said there's no, certiorari is only, we want you to command the minister to make the decision, and they said we don't have to. It's a discretionary decision. It's not incumbent upon him to do it. It's discretionary for the minister here as to whether or not the minister affords procedural fairness. What does that say about the duty? Or am I looking at it the wrong way? Am I just playing devil's advocate here? Just give it some thought.
Righty, just on that, you're distinguishing between duty and the content. I was just wondering, in terms of natural justice and the procedural fairness distinction, Edelman's distinction from the article of what I gathered was natural justice is sort of like this underlying duty, and then the procedural fairness is how it sort of manifests. I was just wondering, consistently, or to apply those terms consistently to what we just talked about, then how that plays out.
Well, I mean, that's the reason why I popped those articles up, because I think they're interesting for you to think about and then formulate some views on. Natural justice hasn't been excluded, only procedural fairness has been excluded. Natural justice is that, equitable duty to act fairly and reasonably, and that hasn't been excluded, and nor can it be. I mean, it just can't be, as a matter of fact, but or law rather. But the words they've used pertain to the procedural steps. So by residing or reposing in the minister a discretion as to whether or not he or she, affords these procedural steps, suggests that there is a propensity for these procedural steps to otherwise be taken. So to some extent, I've answered the question that I posed for myself, which is whether or not this strips the minister of the duty. I think there's a duty to afford procedural fairness. It's just the minister can decide whether or not they'll exercise it, which actually takes me back round when I think about it, and then makes me think, well, if the minister can decide whether or not they'll exercise it, is there in fact a duty?
Yeah, because if he has a discretion, then it's not a duty.
Yeah, I know. But what's the derivation of the duty? Where does the duty come from? It comes from the common law. It doesn't come from statute. But it'd be interesting to go and have a look, revisit M70 and look at the fact that there's no duty incumbent upon the minister to exercise the powers, I think, under Section 48 capital A and 198 of the Migration Act, and just look at whether or not there's any correspondence between those two, or rather, is it just, does the duty to afford procedural fairness exist by virtue of the fact that it affects rights, so there is a duty to afford procedural fairness, or has this act effectively annihilated that duty because it means it's discretionary?
Do not ask whether there's that duty and then say, well, by virtue of the fact of answering all those questions, yes, there is one, but then you look at the scope in the light of national security and then reduce it, which then
that's one way of looking at it. That's one way of looking at it. I mean, or that would be the conservative way of looking at it, I think, because it's consistent with the authorities. But I'm just getting a little bit creative here and thinking, well, maybe there's actually no duty. Maybe the effect of what they've done is to, exonerate the minister of the duty, which would otherwise exist at common law, because they've made procedural fairness discretionary. You see that it's mandatory. At common law, the duty to afford procedural fairness is mandatory, but the language of Section 26 may have effectively relieved them of that mandatory requirement, and therefore it's not a duty. I don't know, have a read of the cases again. No, there's no right or wrong answer. I mean, this is just something that you might want to think about and develop some theories on, and then showcase that thinking in your exam.
And then how does the principle of legality come into that?
Well, the principle of legality probably comes into it to the extent to reinforce the requirement that there is a duty, because it's a fundamental right and freedom.
But don't you say that the courts will always try and read it into it? So if you were to successfully seek judicial review, then it would be a whole other issue?
Well, I'm just looking at 26. The minister is not required to observe any requirements of procedural fairness in exercising a power or performing a function under this Act. Is that the language of a discretion upon the minister, or is that the language of I suppose relieving him of the duty?
With separation of powers, then he might have the discretion, but the courts would still have a duty.
No.
If it got that far? No.
No, I mean, the duty... Lee and New South Wales Crime Commissioner and Lee and New South Wales Crime Commissioner would say, would support this and say, look, principle of legality can effectively be overridden by statute, by words of clear and plain intendment. And I mean, one way of looking at Section 26 is to actually relieve the minister of the duty, to say that there is no duty. Or is it discretionary? Which would suggest that there is a duty, but the minister can afford it. I think the word required is an interesting word, because they're not required, so it's like a relieving them of the requirement at law, potentially.
And that's what I was saying before, that word require makes you think, well, yeah, it's got to be discretion. He's not required, but he can also, it's got the option to change his mind whether if he wants to, or go with what he thinks.
Yeah, potentially. I mean, the minister, there's no duty to afford procedural fairness, but if the minister embarks upon it and starts affording procedural fairness, what then happens? Like, say, for example, the minister, issues a TEO Act or something like that, and a person makes an application for a return permit and says, oh, I've got to come back, and, like our mate Kamal Youssef says, I've got to come back and be with my dad, and he doesn't have to take any of that into account. Puts him straight in prison. But if the minister invites those representations, does the minister then have to take them into account to Section 26? Is Section 26 discretionary in the sense that a duty exists and the minister can pick and choose as to when he or she affords procedural fairness? Or is it, as we've just been discussing, Russell, and says, no, there's actually no duty, which would mean then if the minister then takes it upon him or herself to afford procedural fairness, does it open the floodgate for the full gamut of procedural fairness to be afforded by the minister in those circumstances?
Memo notes actually mention that, say that that's one of the issues.
Which notes?
The explanatory memorandum that
Yeah.
came for this actually mentions that was one of the concerns, that would frustrate the policy's intention of the bill.
Yeah, if the minister, but I know I read that, and that's saying, look, if we have to afford someone procedural fairness, then they're on notice of it, and they can come back in before we've got our shit together, for example, right?
Yeah.
But the point I'm making is a different one. That if this relieves the minister of a duty, that's great. The minister doesn't have a duty, but if the minister chooses to afford someone procedural fairness, then does it, because it relieves them of the duty, but if the minister takes it upon themselves to afford someone procedural fairness, they cannot then thereafter pick and choose as to what aspects of procedural fairness they're going to afford this person. They have to give them the full gamut, because all that Section 26 does then, on one view, is just relieve them of the duty. But if they bring it upon themselves to afford procedural fairness, they're not saved by Section 26. Section 26 only says you don't have a duty, but if you take it upon yourself to afford someone procedural fairness, then you've opened the floodgates to all the common law requirements.
Yeah.
That's one way of looking at it.
Yeah.
Friday, I would argue that there's always a duty to afford someone procedural fairness on the basis of the Constitution and all the case law saying that it's a common law right, but then the scope is reduced dependent on the import or the intendment of the Act and the interests of the public and national security. So to completely read it out would be against all of those provisions.
Mm. There are many ways of looking at it, and you need to think about it. And you need to be able to reason. You need to be able to reason why, and reference to the cases and all that sort of stuff. I mean, that's what I'll be looking for. It's a big question. It's the obvious thing that I'm going to ask you about in this Act. So think about it.
And could it also just be covering themselves because they might not be able to get in touch with the person, or they could be having problems because they're overseas in a conflict zone?
Yeah, absolutely. That's what Russell was talking about. But is it discretionary, or is it just absolving them of the duty? Or, what is it? How does it work? Is it constitutional? Is it unconstitutional? What does it say about the principles of legality? All those sort of things. You've got to think about all that sort of stuff.
It seems like it's a double-edged sword, but it also says that in that memo that the person also will have access to judicial review.
Mm.
So whether the
but
minister,
maybe not on the grounds of denial of procedural fairness.
Well, that's it. Giving them that option gives them that procedural fairness to have judicial review to take it over and review it.
But I think that's one of the purposes of the reviewing authority is that there's a sort of a check and a balance in the fact that a person is unable to represent themselves, so an independent third party reviews the decision for legality. But one of the things about TEO orders is I mean, you can't make any representations to say it wasn't me, I didn't do it. So what implications does that have for all these things that people are, what the critics of the regime with respect to its unconstitutionality?
Sorry, the foreign fighter can't say I didn't do it.
Yeah. So you got the wrong person. So, you know, that the minister has reason to suspect that Bridie Nolan has blown somebody up in, in a restaurant in Bali or something like that. See, for example, the kid over in
Undue influence.
the kid over in Christchurch, he could have a TEO order made against him because he's committed an act of hostility on foreign soil against, a group of people for political reasons, religious reasons, whatever. So he is a terrorist. He could have a TEO issued against him. So say I'm over in Bali and I blow up a restaurant or something like that, the minister decides that Emma McCulloch did it. Emma McCulloch can't say, I didn't do it.
I've got a British passport.
It was Bridie Nolan. That's right. Well, you're gone. Yeah. So that's one aspect of procedural fairness that isn't cured by the reviewing authority because the reviewing authority hasn't had those representations made. And Emma McCulloch might be not allowed to re-enter Australia for the next 12 months.
I'll get a return permit.
No, but a return permit can have as one of its conditions that you can't come in for 12 months.
But then, like the reasons you said before, like without the reason being, Emma doesn't have the reason given, but you can say, because Emma hasn't blown up anything, so she can say that's not, like it's kind of, you can argue, you can still go to the judicial review and say this is unreasonable because Emma hasn't done anything that, or Emma hasn't done anything that is kind of the section 10 to apply.
Yeah, well, I mean, on judicial review would look at either the reasons given to the reviewing authority or whatever the briefing was from ASIO.
And can Emma also go for the application for revocation?
Yep. And then the question is well, on the application for revocation, does the minister have to accept representations there?
I can give a statement of reasons then, can't I, for the revocation? I can say I wasn't in the country at the time or something.
Well, no, you could make representations then and say, no, you should, I'm applying that you revoke this because, I've just been peacefully, at a yoga retreat and I can't imagine how you could possibly think I've committed any terrorist act. Like I've just been, doing child's pose or whatever, or downward facing dogs for the last 7 days. And the question is, well, there's a representation being made. Does the minister have to take that into account if they don't have to afford you procedural fairness?
But 12.3b, so Emma can include under 12.3b that the reasons, Emma's reasons, but there's nothing says minister should read it. Is that what you're saying?
Well, yeah. So does the exclusion of procedural fairness mean the minister doesn't have to take it into account?
Then why does section 12.3b say it can include reasons?
What are you talking about? Section 12.3b.
It's the application to revoke statement specifying reasons.
A statement specifying the reasons. Yeah.
But if he doesn't take it into account, isn't that a failure to give proper consideration?
Potentially. But this is one of the things you've got to think about with Section 26. Section 26 purports to exclude procedural fairness to some extent, but are there remnants of the requirement to afford procedural fairness nonetheless in the Act that are clear, and that you know, it's that clear intention point. So these are the sort of things you have to go and look for in the Act and say, oh, well, it's all very well and good that the minister doesn't have to afford it, but they actually do. And it's, you know, you're in the territory of the law will imply it unless it's absolutely clearly and plainly intended that it's to be excluded. And I remember I've been saying the whole way through, have they successfully done that? And you've just stumbled on one of the arguments as to why they probably haven't. And then what does that mean for whether or not this is a discretion or that it actually absolves them of the duty, all these sort of questions. So it's a much more holistic exercise than just simply looking at Section 26. You need to look at the whole of the Act and the authorities and things like that.
Righty. How do you distinguish this case, the TEO, compared to like Lee's case and Said's case, where they said the intention of that particular legislation was to infringe on rights and freedoms, etc.?
Well, I don't know how you distinguish it. I think that they're fairly similar. And this is what Russell keeps harping back on, is what this is precisely what they intended to do. That's what the explanatory memorandum makes plain.
And that's why the principle of legality was said not to apply in those certain cases. It was rebutted.
But you need to decide whether or not they've successfully done that in this case. You've all gone very quiet. Is there any other questions? I mean, I could sit here all night, but I'm not going to.
Do you think there's going to be a case like soon? Do you think someone's going to go to court and try to bring it to High Court and talk, like complain about the unconstitutionality or about this procedural fairness? Do you think it's going to happen?
Yeah, for sure. I mean, someone will. I don't think there's going to be many of them. I really don't. But I don't think any sound administrative lawyer is going to run a constitutional argument. It's been decided, this question. The people on the Law Council who are jumping up and down about this sort of stuff, bless their little socks, they're not the best administrative lawyers. And it comes from the Human Rights Commission. I mean, that's their job, isn't it? Just to basically complain about any infringement upon human rights and pretend that it's constitutional. But, I mean, the stark reality of administrative law is that, you know, this sort of stuff is permissible. I mean, you're coming into studying law and administrative law in particular at a time when, you know, there is a real prevalence of national security legislation and national security issues, and a lot of High Court authorities and full federal court authorities on the acceptability of this sort of legislative design. When I started, it was like shock horror. They can do this. So, you know, a lot of people are still, who are, you know, forming opinions about this sort of stuff, they're still in the shock horror. They haven't really caught up.
Which brings to the point, this Act is the terminology is ambiguous in some ways. Well, Section 26 is a perfect example of that, where the minister is required. But Chief Justice French and both Gordon both have said in, for instance, French did in International Finance Trust versus the New South Wales Crime Commission, said that those who are required to apply or administer law, who are to be bound by it, and those who advise upon it are generally entitled to rely upon the ordinary sense of the words that Parliament has chosen. So
Yep.
do we just look at the word require and say, okay, well, he's required to the minister's required to look into that or not?
For 26?
Yeah. Because both, as I say, both French and Gordon have both mentioned.
Yeah, there's no extended meaning to the word required. I mean, the word required is a classic example of a word to which you would give it its ordinary meaning, because it's a word that just cannot be given an extended meaning. But for example, I mean, the case that I was talking about in one of the other tutorials, that May case that I was in, the word injury has an ordinary meaning, but it has an extended meaning in the context of the Safety and Rehabilitation and Compensation Act, and required would not in this act. But there would be other words that would have extended meanings. Some of them have defined meanings, but there are other words that would have extended meanings. But yeah, required, you would be entitled to give it its ordinary meaning, and the nuance that would come from the word required is an interesting one and question for your analysis.
Thanks for that.
There wouldn't be anything before the courts yet, I wouldn't think. I don't know anyone who's got any of these cases. It's only just got enacted in July. Do you think anybody else has another question?
Quickly, does the Parliament care about any of this sort of stuff, really, when they're talking about it? So he's answerable to the Parliament at the end of the year. They wouldn't be concerned with any of the, I mean, he'd just sort of give them a list of, we've had 5 applications and whatever.
It has to be tabled.
But he wouldn't stand there going, I didn't accord procedural fairness to this person.
No. It's just he has to table it. Would anyone care? Look, no one cared when it was made. I mean, I put the debates up, and if you had a look at the debates, it was pretty lightly debated. It wasn't wildly debated. They were really only debating amendments. It was never like this legislation should never have been passed. It was all just there are some amendments. The only people who voted against it were the crossbench, but I mean, they're just a bunch of lunatics, I think, anyway. But yeah, I mean, it's not going to, unless national security for some reason has some major political about face. I just can't see this being used as something to whip Dutton with. You never know, Keneally might. You know, it just depends. It's not going to be I just don't think that you'd get any votes from either side of politics about this issue. People just do not want jihadists in the country. That article that someone put up on the Moodle, I mean, this is something I was saying the other day. I can't remember to whom I was saying it. I think I was talking to a friend about this act. And I mean, one of the things I think that everybody is going to have to recognise is that we are, by creating a whole population of stateless people, actually endangering ourselves further. Because one of the things is it's better to have these people under control. It's sort of a head in the sand type attitude that countries are taking with respect to dual citizenship and all that sort of stuff, and renouncing citizenship. I think to some extent states are going to have to take responsibility for people if they want to return.
Well, that's what America was saying, wasn't it? That's what they've come out and said, you've got to take your people back. It's just going to get worse.
Having a whole lot of stateless people is just going to fuel this cause. Look, I mean, radicalisation of Islam, to the extent to which I know anything about it, is it doesn't. People don't radicalise when they're comfortable, and when they're, life is great. They radicalise out of situations of dire poverty, and they turn towards this fanaticism in circumstances where their lives are shit. If you have a comfortable and lovely life, you're not going to go and put it in danger by turning into radical Islam. I mean, that's a generalization, and I think that we just need to recognize that I know it's a very socialist attitude, but we need to take responsibility for people to whom we've given citizenship. It's not something you give away. It's not a lolly bag. It's not just handing it out to anybody. I mean, we need to first look at to whom we are giving citizenship, and then secondly, if we've made the decision to give people citizenship, then we've made a commitment to them. It's sort of like adopting a child, but it's a fraught issue. I mean, I'm not in policy in this area. I don't really know anything about it. I just think we just need to, as lawyers, we can only uphold the legislative intention and make sure it's constitutional. I'm not in politics. Everyone's signing off. Is there anybody else who's still there? We got Russell, Akio. Anyway, I'm not really talking about anything that you're going to need to know for your exam at the moment, but it's interesting. Anybody else have any questions? It's 10 to 10, past my bedtime.
All good. Thank you.
Yeah, thank you.
I've got a few questions here. Hang on, let's see. Mia mentions it. Implied. No, they're all just thank yous and goodbyes. All right, good luck with your exam, everyone. Just post things on Moodle from now on, unless you've got some embarrassing question. But there's no question that's embarrassing. I think a lot of people are probably thinking about the same things, and it's good to see you all answering each other's questions as well, because that, by asking questions on the Moodle, you're forcing other people to engage, and you're answering. You're answering it from different perspectives. So I'll come in and answer some questions, but I think it's productive for you to come and answer each other's questions because it makes you all think. Are there any other legislation? Only the AIA, I think. Evelyn. So Evelyn's just said, is there any other legislation other than those in the Moodle folder that we need to take into the exam, such as the AIA? I think you might need the AIA. Aspects of it, definitely. All right, team. Anything else? I'm just going to... I'll do, unless there's anything further. That's the end of our tutorials.
Thanks, Rob.
Thank you.
All right, gang.
Thank
Best
you.
of luck.
Thanks,
okay. Look forward to reading them. Bye.